This July marks the arrival of 3 quiet shifts targeting American seniors, and each one is designed to drain dollars directly from your wallet. We're not talking about some distant future threat. We're talking about right now, this month. The first can shave down your Social Security payment before a single dollar hits your account. The second gives the government authority to withhold as much as half your monthly benefit, even if you never caused the problem. And the third, the one flying completely under the radar, has the power to eliminate food assistance that millions of older folks quietly count on just to keep meals on the table. What makes this particularly troubling is how these changes were designed to slip by unnoticed. There's no certified letter with bold warnings. No one calls to give you a heads up. Not a single alarm bell. You're expected to discover it when your payment arrives lighter than expected, and by that point, those funds are gone for good. I'm Claire Weston. I work as an estate attorney, and I've lost count of how many times I've watched families discover changes like these just weeks too late. What I do here is straightforward. I dig through the dense legal language so you don't have to, then break down exactly what's shifting and exactly how you can respond, because here's what they won't mention. Each of these 3 changes comes with a legal protection you can use, but only when you know it's heading your way. Stick with me through this. Whether you're 62 or 82, still punching the clock or long retired, because there's a strong chance that at least one of these 3 will affect someone close to you. Pay special attention to that third one, though. It's the change people never notice until the damage is already done. Let's dive into the first change, and it's substantial. As of this July, the federal government is back in the business of docking your Social Security payment to collect on defaulted student loans. Now, I can already hear some of you saying, "Claire, I'm 70 years old. Student loans aren't on my radar." And that might be true for you. But hold on before you move past this, because it's blindsiding people for 2 specific reasons. First, this collection process was on hold for so long that most people forgot it even existed. The pandemic brought a halt to federal collections on defaulted student debt, and that freeze quietly stretched on. Plenty of folks assumed the debt had evaporated. It hadn't. It was dormant, waiting. And now the collection machinery is roaring back to life. The second reason is what really hurts. This isn't limited to people who borrowed for their own education. We're talking about grandparents and parents who co-signed, or who borrowed through parent PLUS loans to give a child or grandchild a shot at college. Your signature is on that loan. When it defaults, the government considers it your responsibility, and your Social Security becomes fair game. Here's the mechanism. It operates through what's known as the Treasury Offset Program. Once a federal student loan enters default, the Treasury gains the authority to garnish Social Security benefits. The cap is 15% of your monthly payment. There is one safeguard, and it matters. They're required to preserve at least $750 per month for you. But let's be honest about what that actually means. Say your monthly check is $1,200. Losing 15% means $180 vanishes every month before you can touch it. On a fixed income, $180 is the electric bill. It's the grocery run. It's the pharmacy copay. Let me paint a real picture for you. Imagine a 68-year-old woman, retired, surviving on a modest Social Security payment. A decade ago, she put her name on a loan so her grandson could attend college. He hit hard times, the loan slipped into default, and everyone moved forward. That loan hasn't crossed her mind in years. Then suddenly, one month her check arrives nearly $200 lighter, with barely any explanation. She didn't mess up. Nothing in her circumstances changed. The only difference is someone in a government office flipped a switch. That's how invisible this process is. And we're not talking about a tiny group. Current estimates suggest roughly 450,000 Social Security beneficiaries are vulnerable once collections resume. A significant portion of them are retirees, depending entirely on that monthly check and nothing more. So here's your action plan, and I need you to take notes. Don't sit around waiting for a shrunken check to appear. If there's any federal student debt attached to your name, including parent PLUS loans for kids or grandkids, you have genuine options available. The problem is most people never exercise them. Option 1 is requesting financial hardship relief. You can submit an application to the Department of Education arguing that withholding this money would make it impossible to cover basic necessities. And here's the stunning part. According to the government's own Consumer Protection Agency, approximately 82% of Social Security recipients with defaulted federal loans would actually meet the criteria for that hardship relief. 82%. The protection is sitting there waiting, and almost nobody claims it simply because they don't know it exists. Option 2 is pulling the loan out of default status completely. This can happen through loan rehabilitation, where you commit to a series of small, manageable payments they agree to, or through consolidation. The moment that loan exits default, the garnishment ends. Your Social Security protection is restored. Bottom line, this isn't an impossible problem. But the solution only works if you take action before, or immediately when, that check starts shrinking. Contact the loan servicer now. Ask about hardship relief and rehabilitation options. Do it while your full payment is still intact. That brings us to the second change. And if the first one got your attention, this one's going to make you lean in, because this change doesn't require you to have any debt whatsoever. Effective now, the Social Security Administration has authority to withhold up to half your entire monthly payment to recover what they classify as an overpayment. Let me clarify what an overpayment actually means, because there's widespread confusion around this. An overpayment occurs when Social Security determines they paid you more than you were entitled to at some point in the past. Perhaps your earnings shifted, maybe a benefit calculation was redone, possibly paperwork got processed behind schedule. And here's the piece that infuriates people, justifiably so. Most of the time, the overpayment wasn't your mistake. It was their error, their calculation, their administrative delay. Yet you're the one they pursue for repayment. For years, the approach was measured. When they recovered an overpayment, they'd take roughly 10% of your monthly check while you worked it off. 10% is painful, but manageable. Those days are done. Earlier this year, the agency moved to bring back a far harsher collection rate. Initially, they announced 100%, meaning your entire check until the balance cleared. Public backlash forced them to compromise at 50%. Half. Let that sink in. Half your Social Security payment withheld, potentially for months, to cover an error you may have had nothing to do with. For anyone living off that check, half isn't just uncomfortable. Half is catastrophic. I've witnessed how this plays out in real life. Picture a 71-year-old man opening an unremarkable envelope. Inside is a notice informing him he was overpaid 3 years back, and they plan to recover it by withholding half his check beginning shortly. He rereads it multiple times. He never received extra money knowingly. He never concealed income. As far as he can determine, any mistake came from their end, not his. Yet this letter isn't requesting. It's declaring. That feeling, that blend of bewilderment and panic, is exactly what 2 million households are facing right now. And the majority of them will assume they're stuck with no recourse. That assumption is the costliest error you can make. This isn't unusual. Based on the government's recent accounting, nearly 2 million beneficiaries have been classified as overpaid, totaling around $23 billion. That's a massive wave of notices heading out and a massive number of checks about to get slashed in half. But here's the encouraging news, and this is why understanding your rights is critical. You are not defenseless when facing an overpayment notice. There are 3 specific actions, and they're effective. Move 1. The moment an overpayment notice arrives, recognize there's typically a window, usually around 90 days, before withholding actually begins. Don't waste that window. That window is your shield. Move 2. If losing that portion of your check would create financial hardship, you can request a reduced withholding rate. There's an actual form designed for this purpose. It's called the Request for a Lower Rate of Withholding. You explain what you can realistically afford, maybe 10% instead of 50%, and you can bring your check back near its full amount while you address the situation. Move 3, and this is the critical one. If you believe the overpayment was their fault, not yours, or you simply dispute that you were overpaid at all, you can file an appeal and request a waiver. When you submit that appeal promptly, it can actually freeze the collection process while they examine your case. The waiver states clearly, "This wasn't my doing, and I can't afford to repay this." Please forgive the debt. People succeed with these requests regularly, but only those who actually file them. So if one of these notices ever shows up in your mail, don't freeze up and don't discard it. It's not a final judgment. It's the opening of a negotiation, and you hold far more leverage in that negotiation than they want you to believe. Now, before we get to the third change, the one I mentioned that almost nobody anticipates, let me take just 30 seconds, because so many of you have been asking where to find all of this in one organized resource. Everything I discuss here. The Social Security pitfalls, the property tax reductions most seniors never pursue, the banking strategies nobody bothers explaining, the exact forms and exact procedures. I compiled it all into one straightforward guide. It's called the Senior Money Playbook. It's written for real people, not attorneys, so you can actually read it and apply it. It walks you through the strategies that safeguard your money and the benefits you might be missing. It's the same counsel I'd give my own parents. If you're interested, the link is in the description below. Check it out after the video. All right, the third change. This is the one I really wanted to make sure didn't get buried, because it's the quietest of the three and it's going to catch the most people unprepared. Beginning this July, the eligibility rules for food assistance are shifting in a way that sweeps in a whole segment of older Americans who previously had protection. I'm referring to SNAP, what most people still call food stamps. Historically, there was a work requirement tied to benefits for younger adults, but older individuals were protected from it. If you were in your late 50s or early 60s, you didn't need to demonstrate employment to maintain your food assistance. That protection is being removed. Under the new law, the protected age threshold is being pushed significantly higher. Adults who don't qualify for other exemptions now must satisfy a work requirement to keep their benefits, and that requirement now extends all the way to age 65. In real terms, this means a substantial group of Americans in their late 50s and early 60s, people who thought they were beyond these requirements, now must document 80 hours monthly of employment, approved job training, or volunteer work to maintain the food assistance they've been depending on. 80 hours a month translates to roughly 20 hours each week. For someone who's 62, possibly dealing with health issues, possibly caring for an ill spouse, possibly already forced out of the job market, that's not a minor demand. Consider a 63-year-old woman who left her position to care for her husband with dementia. She's not retired in any comfortable way. She's working constantly, just without a paycheck. That food assistance has been crucial to stretching their limited income. Under the previous rules, her age shielded her. Under the new rules, unless she submits the proper exemption documentation, she's expected to locate 20 hours weekly of qualifying work or lose that help. The projections are concerning. Experts estimate more than 1 million older adults in that 55 to 64 age range could lose food assistance because of this policy shift. However, and this is crucial, the exemptions weren't completely eliminated. Real protections remain, and knowing these rules is what saves you. You may still be exempt if you're medically unable to work. You may still be exempt if you're caring for a dependent, such as a young grandchild you're raising or an incapacitated family member. If you're receiving disability benefits, either SSI or Social Security disability, that typically qualifies as an exemption. And once you actually turn 65, full exemption is restored. Here's what you need to do. If you or someone you care about falls in that late 50s to mid-60s range and depends on food assistance, don't wait for a termination letter. Reach out to your state SNAP office directly. Ask them specifically which exemption applies to your circumstances and submit the required documentation on time. A physician's statement, proof you're a caregiver, verification of disability benefits. The exemption only protects you if it's officially filed. The people who lose benefits are almost never those who didn't qualify to keep them. They're the ones who qualified perfectly but never submitted the paperwork. Let me tie this all together, because I want you to leave with the complete picture, not just 3 alarming headlines. 3 changes are arriving this July, and they all share one common characteristic. They're designed to operate silently. The student loan garnishment, up to 15% of Social Security benefits, reactivating for hundreds of thousands, including grandparents who co-signed. The overpayment recovery, up to half your monthly payment, often for errors you never caused. And the food assistance work requirement, now extending all the way to age 65, yanking protection from a group that used to have it. But you're not helpless against any of them. For the student loan garnishment, hardship relief exists that most people qualify for but never pursue. For the overpayment, There's a response window, a reduced rate option, and an appeal with waiver that can pause or completely eliminate it. And for the food assistance requirement, exemptions still exist if you apply for them in time. The single most critical thing I can share with you is this. The people who get damaged by these changes are rarely the ones who had no options available. They're the people who didn't learn the options existed until their money was already gone. That's the whole system. These regulations depend on you staying uninformed. So getting informed today is how you protect yourself. Please remember, this is general education, not legal or financial advice for your individual circumstances. The specifics of how each rule gets applied can vary and can shift. Always verify your own situation with the Social Security Office, the Department of Education, or your state benefits office before taking action. But now you're aware of what's coming, and you know the strategies. Do me one favor. Think of one person you know over 60 who's living on a fixed income and share this video with them. One of these 3 changes could be about to impact their payment, and there's a strong chance they haven't heard a single word about it. You might be the reason they protect their money. Thank you for watching. Take care of yourself, and I'll see you in the next one.